In this video, I want to discuss what I mean when I'm talking about incapacity planning with my clients. A lot of people know what estate planning is, right? And they focus on who gets your stuff after you pass away, how do we get to avoid probate court, and all that is very, very important. But in my mind, what's even more important is who can make decisions for you if you become unable to make decisions for yourself. And there are multiple different contexts in which important decisions need to get made. And when I refer to, so incapacity planning is essentially a sub-subject. It's within the context of estate planning. We'll be talking about incapacity planning as well, but sometimes we talk about them separately. If you already have a will and a trust, but you don't have a good enough durable power of attorney or healthcare surrogate designation or living will, then we may be talking about only handling the incapacity planning component of what the important documents that you need. So there are obviously decisions to be made in a healthcare context: who can access your medical records, who can deal with the hospital, who can consent to treatment, who can to make decisions in regards to withdrawing treatment. These are going to be held within the context of a healthcare surrogate designation. In other states, they call it a healthcare proxy. In Florida, we call it a healthcare surrogate. This is the person who makes healthcare decisions. And then in our durable power of attorney, or in our case, typically we're providing a Medicaid compliant durable power of attorney, then it's who can deal with your money, who can deal with your real estate, and who can come to someone like me to say, okay, my loved one who signed this power of attorney needs help qualifying for a Medicaid or getting help paying for care at home, and we don't want to go through all of our assets first. Well, in that situation, you can't go with just a typical run-of-the-mill power of attorney. You need a Medicaid compliant durable power of attorney that allows us to do our more sophisticated planning. So when I talk about incapacity planning, it is 3 documents. It's a Medicaid compliant durable power of attorney, it's a healthcare surrogate designation, and it's a living will, not to be confused with the last will, but a living will is end of life. If you're an end stage permanent end-stage condition, a persistent vegetative state, you have a terminal illness. Essentially, you're alive because machines are keeping you alive. What do you want to happen in that limited set of circumstances? And the decision's up to you. And remember, to whoever makes your healthcare decisions does not need to be the same person as the one who makes your financial and contractual and dealing with the government and asset protection decisions. They can be separate individuals. So sometimes they're the same, sometimes they're different, and we can have a conversation when you come into our office or schedule a consultation to discuss who the right people are to help you make healthcare decisions versus who can help you make financial decisions with our incapacity planning package. If you're anywhere in the state of Florida and you want to learn more about incapacity planning, estate planning, Medicaid planning, long-term care planning, please give us a call, schedule a consultation. We serve all of Florida remotely or in one of our 4 offices. Thank you for watching.